For words just ended someone's freedom, and they never saw it coming. Not a weapon. Not a chase. Not a crime scene. Just a cop leaning into a car window during a routine traffic stop saying, "Hey, we just want to talk." And in that single moment, without being arrested, without being read their rights, without even knowing what was happening, that person said enough to hand law enforcement everything they needed. And I've watched this exact scene play out hundreds of times in cases I've handled as a criminal defense attorney. So in the next few minutes, I'm going to show you precisely what is happening when a cop says those words at a traffic stop, the psychological trap buried inside them, and the exact phrase, just one, that shuts the whole thing down legally and immediately. And before we get into it, if you want videos like this every single week, real legal knowledge explained in plain language, so you can actually use it, hit that subscribe button right now. What I'm about to show you is something most people only learn after it's already too late. Here's the scene. You got pulled over. Maybe a taillight, maybe a rolling stop, maybe you were going a few miles over the limit. The officer takes your license and registration, runs your plates, and comes back to your window. Normal traffic stop. Should be done in 5 minutes. But then instead of handing you a ticket and walking away, he pauses. And he says it. "Look, before you go, we just want to talk to you for a second." Maybe there's a second officer standing at your passenger window now. Maybe they've radioed for backup, and you didn't notice. And in that moment, your entire brain shifts. You think, I haven't done anything wrong. If I just explain myself, this ends. They'll see I'm not involved and let me go. That instinct, that completely human, completely reasonable instinct, is exactly what they are trained to trigger. And it is the single most dangerous thing that can happen to you at a traffic stop. Here's what you need to understand about those words. "We just want to talk" is not a casual request. It is an interrogation technique with a name, a training manual, and a documented success rate. Law enforcement uses it specifically because it makes you feel like you are not a suspect. It's designed to drop your guard by framing what is happening as a conversation between two people rather than an encounter between a citizen and the state. And the second your guard drops, the second you start believing this is just a chat, that's when you start talking. And once those words leave your mouth, you cannot take them back. Not ever. Not in front of a judge, not in front of a jury, not with the best defense attorney in the country. Two officers don't run your plates and then linger at your window because they got curious. They are there because they are building something. Maybe they have a theory, and they need your words to confirm it. Maybe they have almost enough, and your statement is the missing piece. Maybe you are a witness they think they can flip into a suspect. It doesn't matter which, because in every single scenario, the one thing that gives them what they need is you deciding to talk. And here's the part that should make you genuinely furious, because this is not a level playing field in any sense. Law enforcement officers in this country are legally permitted to lie to you during an investigation. The Supreme Court of the United States confirmed this in Frazier v. Cupp. They can tell you they have evidence that does not exist. They can tell you your passenger already told them everything, and if you don't give your side now, you're going to be the one who takes the blame. They can tell you this is your one chance to clear your name before this gets serious. None of it has to be true. They can say every word of it with a straight face, and it is completely legal. So when that officer leans into your window and says, "We just want to talk," what he is actually communicating is, "I don't have enough to move on you right now, but if you start talking, I might." That is the game. And he is counting on the fact that you don't know the rules. Now here is the part of this that should stop you cold. Because you do not have to be guilty for this to destroy your life. The Innocence Project has documented that nearly 30% of all wrongful convictions involve false confessions. Nearly 30%. And do you know how most of those cases started? Not in a bright interrogation room. Not in handcuffs under a single overhead light. They started exactly the way I just described, at a car window, or on a front porch, or in a parking lot, with the words, "We just want to talk." Maybe you answer a few questions because you want to be helpful. You're not hiding anything, so you figure the truth will take care of itself. But that is not what happens. What happens is that a nervous pause becomes documented as deception. A detail you remembered slightly differently the second time you told it, because you're panicking, because two officers are watching your every move, becomes an inconsistency, and that inconsistency becomes evidence of guilt. Your own words, the ones you offered voluntarily and in good faith, get written into a report and read back to a jury in the worst possible light. And the same officer who told you he just wanted to talk is now the one testifying against you. And there is something about this specific situation, a traffic stop, that makes it even more legally dangerous than people realize. Because here's what almost nobody understands about Miranda rights. The police are only required to read you those rights when you are in custody. A traffic stop, even one where officers are asking you questions and keeping you at the scene, does not automatically put you in custody in the legal sense. Which means that everything you say, every word you volunteer at that window, while you think you're just having a conversation, is admissible. No Miranda warning required. No rights read. No tape running that you know about. This is not an accident. This is architecture. The entire encounter is built this way on purpose. So what do you actually do? Because you can't be hostile, that goes straight into the police report as uncooperative and evasive. And a jury hears that you acted like you had something to hide. You can't just sit there silent without invoking your rights properly, because courts have ruled that silence alone, without a clear invocation, can actually be used against you. And you obviously cannot just start answering questions. So what is the move? These are the exact words. Say them out loud right now, so your brain starts locking them in. I don't answer questions without my attorney present. Am I being detained or am I free to go? That's it. That is the entire thing. Calm, polite, firm. And make absolutely sure you are recording when you say it, because you cannot count on a body camera that may conveniently malfunction. Now let's break down why every single word of that sentence is doing legal work. I don't answer questions. That is your Fifth Amendment right, invoked clearly and unambiguously. Courts across this country have held that you must state your right to remain silent out loud, explicitly, or it may not be protected. Saying nothing isn't enough. Saying this is, without my attorney present, that is your Sixth Amendment right to counsel. And the moment you invoke your right to an attorney, all questioning is required to stop under both state and federal law. Every court in the country has upheld this. If an officer continues to question you after you've asked for a lawyer, anything they get from that point forward gets thrown out. Am I being detained or am I free to go? This is the question that forces the officer's hand. He has to choose, legally and on camera. Either he has enough to detain you, in which case he has to articulate exactly what that is, or you are free to leave, in which case this conversation is over. There is no third option. That question eliminates it. If the officer pushes back, and he will, because they are trained to, he might say something like, "If you've got nothing to hide, why won't you just talk to us? This will go a lot better for you if you cooperate." And your response, delivered without anger and without hesitation, is this: "Officer, I am exercising my constitutional rights." That is not evidence of anything, because the Supreme Court has been explicit on this point, Invoking your rights cannot be used as evidence of guilt. Not your right to remain silent. Not your refusal to answer questions. Not your request for an attorney. None of it. Not in an investigation, not in a courtroom, not in a closing argument from a prosecutor. Now, there is one more thing you need to know. If during any of this an officer tells you they have a warrant for your vehicle, for your person, do not panic, but also do not start talking. A valid warrant gives law enforcement the authority to search what the warrant covers, but it does not require you to answer questions. Your right to remain silent exists independently of any warrant. As to see the warrant, read it carefully, and then continue to say nothing until your attorney is present. The search may be happening, but your words are still entirely yours to protect.